Nava's Acadia. In fact, the text document crash reports makes that clear. We were sued for a variety of things by Miss Nava. So we sent over usual interrogatories.
Mr. Butler, I'm so sorry. You need to speak up a little bit. I don't know if you're not feeling well, but you please speak up a little bit.
Is this better?
Yeah, it's better.
I may have been covering up the microphone inadvertently. We sent over the usual interrogatories and requests for production, including contention interrogatories and requests for production. After several extensions, all of which were missed, we filed a motion to compel. On the several hours before that first motion to compel was to be heard, we received the discovery responses, so we took our hearing down. When we looked at the contention interrogatories and the answers, we got basically an answer that said, well, you struck my client, look at the crash report, and we're still developing facts. Well, the crash report exonerates us. All evidence we've seen exonerates us, at least in terms of Miss Nava. Our vehicle never made contact with her. The incident happened October 25th of 2022, so the accident is more than a year old. And so in the second motion, we're asking, one, that the interrogatory answers be verified, which they have not been, and two, to answer the contention interrogatories and request for production, giving us, we need your facts on why you're suing us for negligence, negligent intervention, entrustment, negligent training, etc. Otherwise, since we made no contact with your vehicle, we should be moving for summary judgment. But we know that we need to show that we try to get this information out before we file a no evidence motion. And that's a gravamen of it. I don't see how Miss Nava's can hold us liable, since we never made contact with her vehicle or anybody else's vehicle before the collision. We were just a bystander that got caught up in the resulting aftermath. And so that's why we're asking for those contention interrogatories and requests be answered, or at least say, you're right, we don't have anything against you, we need to drop you from the case. And we're not seeking sanctions, we're just seeking a final answer one way or another on how we're involved with Ms. Nava's claims.
All right, Ms. Morales?
Yes, Your Honor. The complicating thing in this case is that with the first impact by Mr. Gillard, my client lost consciousness, and so she's got, she blacked out, and so she doesn't know exactly what happened, except that she got struck from behind. She's been countersued by defendant Gillard, and so our position is it's difficult to answer these contention interrogatories. We need to get some more discovery from the defendant's depositions, so we can piece it together. And if Smyrna Ready Mix isn't a proper party, then that's fine. But it's also complicated by the fact that defendant Gillard's estate has sued us as well. And so we just need to get some more information from the defendant so we can try to figure out what happened and move forward.
Okay. Response?
Yes, Your Honor. This is literally a description of someone trying to conduct discovery. It's my discovery. I'm trying to find out what they have. There are, not only is there the crash report, but there's also numerous videotapes from the body cams and car cams of all the Louisville Police Department officers who responded to the wreck. I viewed all of those. There's no indication of this. I shouldn't have to try and prove a negative through my discovery responses to them that I have nothing to do with this. They're the ones, someone signed their name to a pleading that said they had a reasonable basis in fact and law to bring these claims against us. And they needed that at the time when they signed their pleadings. And so the idea that they needed to conduct more discovery after more than a year after the accident to try and find something to back that up, I found a bit disturbing, to say the least. They've had time to try and find this, and you can give them some more time, but at some point, if my client had nothing to do with the collision between Ms. Nava and Mr. Gillard, which we didn't, our clients, then we need to have those claims dropped and remove this case and move so we can move this case forward.
All right, Mr. Butler, is this the order that you are moving on here? I just want to make, there was a couple of things filed right at the same time. I want to make sure I have is this the correct order?
No, Your Honor, I believe that is the order from the first round of motions to compel, that we took that hearing down because
Okay,
they supplied us with discovery responses shortly before the hearing.
all right. So what, did you submit an order, a proposed order for this?
I believe I did, but if I failed to, I will commemorate whatever the court's ruling is.
Well, I'd love to be able to sign it now if I can. Let me see.
It should have been filed contemporaneously with our second motion earlier this, well.
So was it on 11/10? Is that when you filed? It looks like you may have filed it on 11/10. Let me try that.
That sounds about right.
Okay, let me see. Okay, here we go. Let me try this. So is this the correct order right here?
Yes, sir, that is it.
Okay. All right, I'm going to go ahead and grant the motion to compel. And you need to start, Mr. Morales, you need to start moving forward on this case. You need to start getting depositions set up and conducting discovery if you're not sure what's happening. It sounds like there's a police report and body cams. Maybe review those to make sure you have the right parties, if what he's saying is correct. So, but at the very least, you need to go ahead and respond to the discovery so far. So, anything else, guys?
Not for moving, Your Honor.
Opiate, Your Honor. Thank you.
All right. You have a great rest. Great. And I'm sorry, Mr. Smitek, do you want to say anything?
No, Your Honor.
Okay. All right. You have a great rest of your day, guys.
Thank you. Thank you, Your Honor.
You too.
Your Honor.
All right. Our next hearing is a scheduling conference on Alois Earms versus Allstate Texas Lloyds. Anyone here on that case? Anyone here in that case for scheduling conference? Garza versus A to Z Printing, motion for continuance. Anyone here in that case?
Yes, Your Honor.
Yes, Your Honor.
All right. So who's here on this case? I could barely hear you guys.
Jessica Babawi here for the plaintiff.
Okay.
Antoine Cobbin here for defendant.
Okay. All right, you may proceed.
Yes, Your Honor.
Go ahead.
Yes, Your Honor, we filed a motion for continuance on this. We're set for trial tomorrow, but to my belief, opposing counsel and them are going to withdraw, and there was no court availability for us to have the motion to withdraw hearing before the trial date for tomorrow. And so we're asking for like a 30-day just continuance.
Okay. Response?
Oh, Your Honor, I can barely hear you now. Can you hear me?
Yeah, can you guys not hear me?
Oh, there you go. Now I can hear you again. I don't know what happened. Yes, Your Honor. So my understanding is there was a motion for continuance. It was actually filed before our withdrawal motion on other grounds. We're in agreement with it. That's fine. We also filed a motion to withdraw. We have not been able to have the hearing on that yet. Based on my discussion with the client, he does kind of want to, we're not in agreement, and he wants to get a second opinion on the case. So in order for us to facilitate that, we need to be able to have that withdrawal hearing.
So one thing I would say to you, because you guys have filed a lot lately in my court, I'm sure in a number of different courts, and I've had this come up a couple times with your firm. The if you'll file a 10-day letter with your motion under the local rules, you don't need to have a hearing on your motion to withdraw as long as the other side, as long as your client doesn't object. And that's the standard way that most people do motions to withdraw. It allows it to go a lot quicker, but you guys don't do that. And so it causes us to you have to have a hearing, and it slows the whole process down because I know it takes time to get a hearing. And so it doesn't look like there's been a request to set the motion to withdraw.
Well, my assistant tried to, but there wasn't a date prior to the trial setting. But then I realized we had the continuance already, so I was like, well, we'll just bring it up then and see what he wants to do. He may not want to grant it. I don't know. I'm not familiar with what a 10-day letter is, so that's probably why we don't do it. But I'll get that figured out and sent in.
It's in the Dallas County local rules. So I would look up the Dallas County local rules, and it's something that's very standard in these things. It's a 10-day letter and allows you to basically, as long as you put the client on notice, what most people do is they send a letter, then they attach it to the motion to withdraw. And then as long as there hasn't been an objection during those 10 days, then the court can grant it without a hearing. But since y'all don't do 10-day letters, you have to have a hearing unless there's a client consent that's signed off on. And so anyway, just some advice that would allow these things to go quicker. But
and so that's better if when the client's not the client's not objecting to our withdrawal, so that's when you would do the letter.
Yeah. Is your client objecting to the withdrawal, or are they just objecting to, what are they objecting to exactly?
They're not objecting to our withdrawal at all. They didn't want us to non-suit the case. It's past statute. They wanted to continue, and perhaps with another attorney.
Okay.
But so then we just needed to withdraw.
All right. Defense counsel, when did you want to reset this for trial?
If we can reset it for trial. What's the I guess the furthest out availability date? I guess to give the client time enough to try to find another counsel if they're able to.
We don't really have any good times necessarily. So what do you feel like you want?
And we can do probably sometime in March.
Okay. How about March 19th?
March 19th. Okay.
So Rhonda, let's go ahead and set this for trial on March 19th.
Okay.
And then Ms. Babawi, why don't we go ahead and set your motion to withdraw for December, look at this real quick, December 18th.
Okay, and so just to be clear, this is the 10-day letters going forward. I don't need to do that for this one. We're going to do the hearing.
No. What you need to do now is go ahead and notify your client that there's a hearing on December 18th and give them the Zoom link. We'll go ahead and set this at 9:45.
Okay.
On December 18th. And but future cases are just you wouldn't have to go through this additional step, and the court wouldn't have to go through this additional step if you had a 10-day letter. So you just look at the local rules, it's pretty clear. All right, guys, you have a great rest of your day. And Ron, did you get all that?
Yes, Judge, I got it.
Okay.
Thank you, Your Honor.
Thank you, guys. You have a good day.
Yes, sir.
All right, Legacy Bank and Trust versus 7750 Windsor High Rise LLC. Anyone here on that case?
Yes, Your Honor. Here, Kyle Chiefs here with Legacy.
All right, Tony, let's go on the record on DC 2319419 Legacy Bank and Trust versus 7750 Windsor High Rise. Counsel, make your appearance.
Your Honor, this is Kyle Cheeves with Legacy Bank and Trust.
And this is Francis Majori on behalf of 7750 Windsor High Rise LLC. Your Honor, I don't know if my client's been served yet. So I'm not waiving any rights with respect to my answer.
Okay, maybe I'm confused. Are you not the attorney for the defendant?
I am, but we've been in contact with the bank, and I learned on Thursday that there's this hearing. My client had, and there's a lawsuit, which we didn't know. They sent me a copy of the papers, but my answer date hasn't run yet. So if there's
I get it. This is not a post. I'm confused. Is this a post judgment receivership?
No, Your Honor, it's just a banking relationship, and they're the lender and we're the borrower, and they want to appoint a receiver.
Okay.
But
I can.
we have it.
Sorry.
Yeah, Mr. Chivas is probably going to announce an agreement. So go ahead.
Go ahead.
Sorry, Your Honor. This is an emergency motion to seek the appointment of receiver. However, when we filed, we were unable to get in contact with the borrower. Since then, so Mr. Majori was just saying we've now gotten in contact and we are currently working on a resolution, and which includes discussions to secure the property. We came to an agreement actually in the waiting room today via email that we're going to make best efforts to come to a resolution. I believe a call is scheduled for later today with both clients. And the hope is that a resolution can come to, and in the event it doesn't, we can continue on with service, get them involved in the case, and reset the motion to get an appointment of a receiver.
Okay. Is there already a judgment in place in this case? There's no judgment in place like from another cause?
No, Judge.
No, Your Honor.
Okay. All righty. So you're just passing the hearing basically.
Yes,
that's correct. And I just didn't want my appearance in this hearing to be a waiver of any of my defenses, which I haven't assessed yet.
Oh, okay. No problem. And we'll Rhonda, go ahead and put this on a 90-day DWAP since they may be settling it.
Okay, Judge, I got it.
Okay. All right, guys. Any questions?
I am hoping this isn't the case, but there's a foreclosure pending for tomorrow. If we don't reach agreement with the bank, we may try to see Your Honor again before 10 o'clock tomorrow for a TRO.
Okay, good luck.
I understand. I didn't want you to see me tomorrow and then wonder why I didn't even mention it. And that's why. But I hope I don't see you tomorrow, with all due respect.
All right. Thank you so much. You have a great rest of your day.
Thank you.
All right. Veritex Community Bank versus Healthy Treats. Anyone here on that case? Mr. Reyes, what are you here for?
Yeah, Your Honor, I'm here for Counsel Joe Cordiguera on the for the plaintiff Santiago Ramirez versus Continental Carbonic Products. This was a dismissal hearing this morning that the plaintiff, my colleague, is sick and he couldn't appear. So kind of last minute, they told me, "Can you show up to this?"
All right, let me look this case up again. What is the name of the
everybody
case?
else if
What's the name of the case?
Give me 1 second. Santiago Ramirez versus Ernest Laprade and Continental Carbonic Products, 2 defendants.
Let's see this case. Let me see.
It was on your DWAP docket, my understanding.
Here it is. Yeah, it's already been moved. Let me just tell you what the status is.
Okay.
It's been reset to January 29th to 24.
January 29th. Okay. All right, and I appreciate that. And I apologize for not having the counsel present at the time. I think he was sick and I was known last
You didn't need to show up anyway, so I hope you weren't waiting too long, but the case was already reset.
Okay.
All right. Thank you so much.
All right. Thank you.
Yes, the other
Right.
question is.
Mr. Sarles, what are you here for?
I'm here for a hearing on Rule 91A motion, Your Honor. A third-party defendant
in Marcia Johnson Upshaw versus Dr. Jeffrey Standifer versus Tom Pop.
Hey, Judge, Paul Dunnigan.
Oh, hey, how you doing?
Doing great. Good to see you. I'm going to be sitting here beside him.
All right. Well, we're going to be taking a quick break. Tony and I haven't had a break all morning, so we'll reconvene in 5 minutes.
Sounds great. Thank you, Your Honor.
From off stage. Right.
Exit stage, right. We need to change the filter on that water. The refrigerator. I don't use it, so I don't know. Yeah, every 25 or 30 years, you're probably supposed to change that. I don't know.
I'd hate to look at it.
How does she pronounce her name? Melanaise?
Mayonnaise.
Melanaise. I thought that was right, but I didn't see the A in it. Here was Crenshaw connecting. Close the door. Give me the phone right. Yes, I'm not good. I silenced my phone, but now I'll forget. For 2 days, I'll wonder why nobody's calling me.
Everybody be mad when you
I'm not answering. Yeah. hearing. Is it only?
All right, is everyone here on the Upshaw versus Standifer case?
Your Honor, the defendant counter plaintiff is here, Dr. Standifer and his counsel.
And third-party defendants counsel for Tom Thumb and Elizabeth Gaska is here, Your Honor.
And plaintiff is here, Your Honor.
Are we missing anybody?
No.
I'm sorry, Dr. Standifer was supposed to join us. I don't see him.
Do we need to wait for him? It's not 10. It's not 11 o'clock yet.
Yeah, he said he was signing in, Your Honor.
Okay.
I'm gonna mute and check on him. Thank you.
Okay, we can wait.
Your Honor, he said he's there, but it's still looping to be let in.
He's not in the waiting room. I don't see him.
Not okay. All right, let me check again.
Judge, did anything happen on the Vertex Community Bank case?
What case is this?
That's right before Upshaw.
Oh, I don't think anyone showed up for that. Is anyone here on Vertex?
Okay.
It's 11 o'clock. We're going to go ahead and go forward.
We're ready, Your Honor.
Ready, Your Honor.
All right, let's go on the record on DC 22-14620 Upshaw versus Standifer. Counsel, make your appearance.
Gary Sarles, Your Honor, for third-party defendants Elizabeth Gasca and Tom Thumb.
E. Renee Crenshaw for the defendant, counter plaintiff Dr. Jeffrey Standifer, Your Honor.
Your Honor, Melanie Henderson Love for the plaintiff, Ms. Upshaw.
All right, let's proceed.
Your Honor, our motion is under Rule 91A of the Texas Rules of Civil Procedure. It's a motion to dismiss by third-party defendants Gasca and Tom Thumb. As you know, I know you've handled a number of these. Rule 91A examines the allegations and takes them as true. It expressly prohibits the consideration of evidence in ruling on the motion. So essentially what the court's looking at are the allegations of the third-party petition, which also asserts a counterclaim against plaintiff Marcia Johnson Upshaw. If I can share screen, Your Honor, I will.
Your Honor, I'm going to object to the third-party defendant, Tom Thumb, making this argument for the plaintiff. This is the plaintiff's petition. This is the plaintiff's argument under the TCPA anti-SLAPP statute, demonstrating and arguing that it was her petition to the court that has been violated by Dr. Standifer, not Tom Thumb. So this is plaintiff's case. Plaintiff has filed a motion for protective order that she also set for hearing today. So this is plaintiff's case, and I would object to Tom Thumb proceeding on behalf of the plaintiff, unless we're saying this is the doctrine of respondent superior. And even if it does apply in this case, this is plaintiff's argument in case.
I'm not sure I understand the objection, Your Honor.
Yeah,
The
I know
objection
I
is
don't
that this is plaintiff brought this case before in the 68th Judicial District Court. Plaintiff filed an anti-SLAPP and TCPA petition with the court. I'm objecting to Tom Thumb making this argument on behalf of the plaintiff. This is plaintiff's case.
I can solve that, Your Honor. I'm not making any argument on behalf of the plaintiff in the case. My clients are Elizabeth Gasca and Tom Thumb, the third-party defendants that have been sued in the case by Dr. Standifer. So I don't know what this is all about, but I'd like to proceed with, and it's not at least initially, because I don't think we frankly need to get there. This is a Rule 91A motion to dismiss the third-party petition against the third-party defendants in the case.
Well, I'm not sure exactly what's going on either, but to the extent that you're trying to affect any claims that Ms. Upshaw has against Mr. Standifer or Dr. Standifer, I'm not going to allow you to make that argument. Are you trying to make that argument?
No, Your Honor.
Okay. All right, then let's proceed.
Okay. If Your Honor can see, although this is denominated a counterclaim, and we're denominated by Dr. Standifer's pleading as counter defendants, very clearly, since Tom Thumb and Ms. Gasca were not plaintiffs in the case and were brought into this case by this Dr. Standifer third-party petition, this is a third-party petition under Texas Rule 38A. It's not a counterclaim third-party petition. So under 91A, we need to look at what has been pled by Dr. Standifer against Ms. Gasca and against Tom Thumb. The only allegation against Tom Thumb and Ms. Gasca is this allegation that is here in, it's actually denominated damages. It's in paragraph 27. This is the defamation claim that's apparently made against everyone. But again, there are no specific allegations. In fact, there are no allegations made against either Ms. Gasca or Tom Thumb. As you can see where I've highlighted in paragraph 27, all of the allegations are against the plaintiff in this case. When we look back at the factual allegations that are here, this is about, Your Honor, on February 1st, Dr. Stanifer went to the Tom Thumb store. There was a lady in line, Esmeralda Gonzalez. She was attempting to buy a case of beer. She didn't have her ID on her. Ms. Gaska, who was a 17-year-old high school student, was our cashier, declined to sell it to her because she didn't have her ID with her. Dr. Stanifer offered to purchase it for her, but he said he was purchasing it for her. Ms. Gaska continued to decline under company policy to sell it to someone alcohol to someone who was purchasing it for someone else. Ms. Marcia Johnson Upshaw, the plaintiff, was the supervisor for Ms. Gaska, my teenage defendant, or third-party defendant. She came to the checkout stand, and then there was, for lack of a better description, and we've provided on the TCPA motion, we've provided a video of the event. When we get to the TCPA part of this presentation, the court might want to watch that 2-minute video, but that altercation that's captured on the iPhone video is essentially what this case is about. There were words that were uttered by Dr. Stanifer against the people there at the checkout, which included the plaintiff, included Ms. Gaska, and included an off-duty DART police officer who was there as private security. So that's what this claim is about, what was said and then what transpired thereafter. And so the allegations, though, that actually plead Dr. Stanifer out of court in this proceeding are paragraphs 19 and 21 of this factual background that's alleged here in the third-party petition against Ms. Gaska and Tom Thumb. On February 1st, 2022, plaintiff, that would be Ms. Marcia Johnson Upshaw, not Ms. Gaska. Plaintiff waited until defendant had left the Tom Thumb premises, and then plaintiff filed a false police report with the Dallas Police Department. That's the subject of at least half of Dr. Stanifer's third-party petition and his counterclaim. Paragraph 21 specifically states that on or about February 11th, defendant, that's Dr. Stanifer, was informed that there existed allegations of him having assaulted a Tom Thumb employee cashier, Elizabeth Gaska. So then we go back to paragraph 27 and we look at, well, what exactly is asserted against Tom Thumb and against Ms. Gaska? And there's nothing that's asserted in paragraph 27 other than that plaintiff libeled and slandered Dr. Stanifer's name and reputation. That's important when we get to the TCPA part of this, of Ms. Gaska's motion, because there's no allegation of a bodily injury, of physical damage to Dr. Stanifer's body. This is a reputational injury claim that Dr. Stanifer was libeled and slandered by two means. First of all, in a false police report, and second of all, in filed false pleadings alleging that Dr. Stanifer assaulted the plaintiff. None of those statements, those alleged defamatory statements, are attributed to Tom Thumb or to Elizabeth Gaska. You can also see, Your Honor, that paragraph 9, or Roman numeral 9, alleges an attorney's fee claim. This is the only other claim besides the claim for reputational damages. It's a claim for attorney's fees under 37009. That's the Texas Declaratory Judgment Act, but there's no claim for declaratory relief asserted.
Can I ask a question? Because I think I'm missing something here. What was the plaintiff's role in all this? She was the person that the alcohol was being bought for, allegedly?
No, Your Honor.
He was the supervisor.
The plaintiff was the supervisor of the cashier. Tom Thumb initially alleged that Stanifer assaulted the cashier. Then all of a sudden we have this lawsuit that says that Dr. Stanifer allegedly assaulted the plaintiff. So that's how Elizabeth Gasca is involved in this lawsuit, regardless of what's alleged in these pleadings. The law says that we take the arguments of the pleadings as well as the arguments at today's hearing into account when making a determination of whether or not a case should be dismissed.
To answer the court's question,
I answered the court's question.
He was asking. He was asking.
I don't know if he was asking you because he.
Guys,
Flanagan was talking.
I'm just trying to figure out the role of the plaintiff. The plaintiff was the supervisor of the cashier,
right?
And she has sued Dr. Standifer for assault, or what did she sue?
Yes, Your Honor.
Okay, that's all I'm trying to figure out. Okay.
Thank you, Judge.
That's it.
All right. Response?
Oh, I haven't gotten a fraction of the way through this, Judge.
Okay, go ahead then.
All right. And we've cited this in our motion in the Bethel versus Quilling Sealander case. The Texas Supreme Court in 2020 allows for the dismissal on 91A based on an affirmative defense. That was a change in 91A jurisprudence. We have moved the third-party defendants, the cashier, the teenage cashier that initially declined the sale of this case of beer, and Tom Thumb, her employer, the cashier's employer, have moved for summary judgment on this third-party claim against them that Dr. Standifer has asserted based on the 1-year statute of limitations. 16.002A gives you 1 year to file a defamation claim. We've also moved on the judicial proceeding communication privilege. It's an absolute privilege that some of the courts have referred to as an immunity. The statute of limitations, as we just looked at, February 1st, 2022, that's the alleged date of the publication of the information to the police, right there, pled paragraph 19. The original third-party petition that Dr. Standifer filed, that's in the court's file, was dated August 14th of 2023. So it's barred because it's more than 6 months after the 6-month statute, after the 1-year statute of limitations. The second argument that's come up is whether there is some type of discovery rule that's applicable here that saves Dr. Standifer's third-party petition on this filing of the police report, which the police report, there's not an allegation that Ms. Gasca or Tom Thumb filed the police report. So I'm not really sure why we were sued to begin with, but assuming that somehow or another that we're involved with the police report, the discovery rule does not apply. The Dallas Court of Appeals has specifically said that if you want a discovery rule to apply, you have to plead it. The Texas Supreme Court has held that since 1988, that if you're going to apply the discovery rule, you have to plead it. We can look through this. There's not an allegation of the discovery rule anywhere in Dr. Standifer's amended third-party petition. So the reason, though, is not because someone's overlooked something. It's just simply that the discovery rule applies categorically. And the Texas Supreme Court has only applied a discovery rule if you can establish two elements. First of all, that the nature of the injury incurred is inherently undiscoverable. And secondly, that the evidence of the injury is objectively verifiable. In the Ellert versus Lutz case, 930 Southwest 2nd, 152, the Dallas Court of Appeals looked through those two elements and held that there is no discovery rule that's applicable to defamation claims. And as recently as 2021, the Texas Supreme Court in a case Hogan versus Zoani, 627 Southwest 3rd, 163, said, this is a quote, "We've never held that the discovery rule applies to defamation claims except in the narrow circumstance involving a person's discovery of allegedly libelous information filed with a credit agency. We have suggested that for defamation suits, accrual generally occurs the date the publication is made." So there's no discovery rule that's applicable to defamation claims here. But even if there was, we have this paragraph 21 that we looked at, Your Honor, that specifically says that on February 11th, Dr. Standifer was informed that there were allegations of him having assaulted a Tom Thumb employee. So Dr. Standifer has essentially judicially admitted that he's discovered everything that he needed to know on February 11th, 2022, but he didn't file this third-party petition until August of 2023. I've got another case here that I'd like to share with the court. It's Morris versus Unified Housing Foundation, Inc. from the Dallas Court of Appeals in 2015. Came out of the 14th District. It's essentially a case about a dispute and altercation in a parking lot of a apartment complex with off-duty Parkland Hospital and City of Dallas police officers. And the appellants had filed defamation claims in the case, as I've highlighted here in the right-hand column of this portion of the Dallas opinion. And they specifically rely on the Ellert case that there is no discovery rule for defamation claims. And they specifically go through and state that, well, we don't know exactly when this happened, but the police reports dated December 13th, 2009, and that's barred by limitations. Well, here, better than the case that's in front of us, this Morris versus Unified Housing case, here the plaintiffs or the third-party plaintiffs' claims against Gasca and Tom Thumb specifically state that the police report that apparently contains, at least in Dr. Standifer's mind, libelous pleadings against him or libelous statements against him about an assault. We have the exact date. It's pled in this petition. And so here the Dallas Court of Appeals said, based on that plaintiff's live pleadings and the absence of a discovery rule, the accrual argument on this defamation issue has to be overruled, that it doesn't apply, and the plaintiff has essentially pled him or herself out of the court by pleading that they discovered what they needed to do here and by pleading the date of the police report. So in this case, all of Dr. Standifer's claims against Gasca and against Tom Thumb, they are barred under 91A. Everything that relates to the statute of to the police report, this allegedly false police report. Again, there's not an allegation that Tom Thumb filed it or that Gasca filed it, but whatever's in it, however it somehow applies to my clients, all the claims regarding that February 1st, 2022 police report are barred. So there's certainly no basis to keep Gasca in the police in this case. The second basis, the second defense to these claims, and our basis for the 91A motion to dismiss, you'll recall, Your Honor, that there is this allegation in the first amended counterclaim. It's actually a third-party petition that says that there's a false police report and filed false pleadings. Well, the time this was filed, there were no pleadings that had been filed by Gasca or Tom Thumb. So I think this is an allegation against the plaintiff more than it is against Tom Thumb and Ms. Gasca. But regardless, whatever it is, there is in the state of Texas an absolute unconditional privilege in judicial proceedings and relating to judicial proceedings that bars any type of claim, not just a defamation claim, but any type of tort claim against a party based on a pleading in a lawsuit or a filing in a lawsuit. The lead case on this we've cited to the court in our motion is Landry's versus Animal Legal Defense Fund from 2021 from the Texas Supreme Court that says that judicial proceedings privilege provides that any communication made or allegedly made by a witness, counsel, parties, the judge, jurors in a judicial proceeding cannot serve as the basis for a defamation action. And the language that's important is, and this is a quote from Landry's, regardless of the negligence or malice with which they are made. So essentially, it is an absolute privilege. As we've cited cases in our motions, it is essentially the equivalent of an immunity. Later on in the Landry's case, the Supreme Court says, although commonly applied in defamation cases, the privilege prohibits any tort litigation based on the content of the communication at issue. So between the statute of limitations that bars everything regarding the allegedly false police report and then the judicial communications privilege that bars anything about filed false pleadings, those two defenses cut down this lawsuit or third-party petition against my clients. We've cited a case, we block quoted it in both Tom Thumb and in Ms. Gaska's motions to dismiss under 91A. It's Strickland versus iHeartMedia from the San Antonio court earlier this year that says that if a plaintiff cites statements from a court proceeding as the basis for a defamation suit, the suit is subject to dismissal under 91A. So all of those allegations about false pleadings are barred by that privilege. Now, Ms. Gaska, separately from Tom Thumb, has also filed a TCPA motion to dismiss as part of her motion to dismiss, Your Honor. And under section 27.003 of the Texas Citizens Participation Act, if a legal action is based on or is in response to a party's exercise of the right of free speech, right to petition, that party may file a motion to dismiss the legal action. And so unlike 91A motions where you can't consider evidence, actually a TCPA motion to dismiss, as I'm sure you're aware, requires the court to consider evidence on both sides. And we think one of the most useful to the court pieces of evidence that captures the altercation or the dispute, the cussing and ranting and raving by Dr. Standifer against the company's employees is the 2-minute video that we've attached to Ms. Gaska's motion under the TCPA to dismiss. It's the 2-minute video. It's worth the court's time to review. I won't waste everyone's time to watch it this morning, but it shows the incident.
I'm going to object to what the attorney is stating the video shows, Your Honor. I'm also going to object as to it even being brought up today because neither counsel has provided the court nor opposing counsel with any exhibits for today's hearing.
Yes, Your Honor. It's attached to the appendix that was filed in this case with Ms. Gaska's motion to dismiss. So I'm not sure why counsel doesn't have that, but the entire appendix was provided to the court and provided to counsel when it was filed in this case with Ms. Gaska's motion to dismiss. The only evidence that has been presented on this TCPA motion has been filed by Ms. Gaska. Dr. Standifer has not presented any evidence to the court in response. Now, Your Honor, I'm sure because you've handled TCPA motions in the past, it's a two-step process. The first process is the showing that the TCPA applies and the statute says a court shall dismiss a legal action if it's filed in response to the movement's exercise of either free speech or right to petition. The Dallas Court of Appeals has had a number of these cases, and quite recently, Hill versus Kelleher, which is a January 25th, 2022 case, a petition denied already. It states that reporting crimes and making statements to police regarding incidences of perceived wrongdoing implicates the right to petition. It also specifically says that, quote, filing a police report, whether true or false, implicates a person's right to petition the government. The Dallas court has recognized that matters of public importance, and this is one of the issues that you have to, when you're petitioning the government for TCPA applicability, you have to show that it is a matter of public concern or public importance. And the Dallas Court of Appeals in a case, and this is cited in our motion, Fishman versus COD Capital Corp., which is a 2017 Dallas Court of Appeals case, they cite favorably and adopt the thought processes of the Fort Worth Court of Appeals in a case and say that matters of public importance or public concern are not limited to reporting criminal conduct, but can include misconduct like statements, quote, about a children's baseball coach angry and aggressive behavior during a game. In that Fort Worth case that the Dallas court has now twice cited favorably, one of the coaches in a little league game started ranting and raving against one of the teenage umpires that was umpiring the little kid's baseball game. And that got out into the community and statements were made, and that was ruled to be a matter of public importance. And we think the analogy here to what you'll see on that 2-minute video that we've provided the court and counsel, that there is certainly a angry and aggressive behavior displayed in this.
I guess my question to Mr. Sarles is,
yes, Your Honor.
Me viewing the video doesn't seem appropriate under the 91A or under the TCPA. I mean, I'm not supposed to be considering evidence. I'm just supposed to consider the pleadings, correct?
No, Your Honor. Under the TCPA, you have to consider evidence by both the movement and the non-movement. Under the 91A motion, that's true. You can only consider what we have up here on the screen, which it really isn't anything.
Well, you can under 91A motions, you can consider limited discovery that's been produced by both. Has this been produced in discovery?
Yes, Your Honor. We provided it to the court. There's actually a separate federal lawsuit, a Section 1981 claim, pending between Dr. Standifer and Tom Thumb in front of federal judge Barbara Lynn and Magistrate Judge Renee Tolliver across the street from us here. So these have all been provided in our initial disclosures in the case. We've attached them to Ms. Gaska's motion. Tom Thumb did not file a motion under the TCPA. Only Ms. Gaska did. But Ms. Gaska attached the evidence in support of her motion to dismiss under the TCPA. In part, this video, we think, shows that
was this video exchange and discovery in this case or the federal case?
Both, Your Honor.
Both, okay. All right. Response.
So it's before the court.
Mr. Sarles, response.
Okay, thank you, Your Honor. First, Your Honor, it is Dr. Standifer's position that Tom Thumb nor Lisbeth Gaska have standing to bring a motion to dismiss under the anti-SLAPP statute, as again, the statute applies to the initial movement or party who is bringing the action. Second, Tom Thumb is required and Lisbeth Gaska are required to show demonstrable harm, which neither of them have done under the statute. The anti-SLAPP statute also states that a party would have to have a meritorious claim, as well as show that the party responding is to their lawsuit is filing the lawsuit in retaliation to that initial claim. Standifer's lawsuit preceded the filing of both Tom Thumb as well as Gaska's lawsuits. So therefore, the anti-SLAPP statute wouldn't even apply, and Gaska wouldn't even have standing to bring the anti-SLAPP or argue the anti-SLAPP statute, just based upon the anti-SLAPP statute. Additionally, Tom Thumb asserts that Standifer's claims are barred under Section 16.002A of the Texas Civil Practice and Remedies Code, and that they argue that the slander by plaintiff occurred 1 year prior to Standifer filing his lawsuit with the court, or more than 1 year prior to Standifer filing his lawsuit with the court. However, this is not true, as Standifer did not even become aware of the police report, which was used as the basis for plaintiff's filings in this claim, as well as Tom Thumb and Gaska's filings in this claim, until Tom Thumb's attorney sent an email to Standifer on February the 24th of 2023. Standifer was not even served with plaintiff's lawsuit until July of 2023. Standifer then filed his claim against the plaintiff on August the 24th of 2023. Therefore, Standifer's claims are in fact timely under section 16.002A. The let me move on. Next,
Well, let me ask you some questions about that because I'm not sure I'm fully following. So, statute of limitations for defamation is a year, correct? I think we can all agree on that. And you're arguing that the discovery rule applies because Standifer didn't know about the
police report.
The police report until when?
An email was sent from Tom Thumb's attorney. I believe it was done again, and it wasn't sent to Standifer until February the 24th of 2023. That's when Dr. Standifer first became aware of the defamation, which was encompassed within the Dallas police report. Up until that time, he didn't know that the police report had even been filed. So once he found out about that, he wasn't even served with plaintiff's lawsuit until July of 2023. Although plaintiff had filed her lawsuit, I believe 8 months prior to that. They had waited for a moment such as this, Your Honor, is our argument. And then plaintiff doesn't file his claim until August the 24th of 2023, which was 6 months from when he learned of the police report containing the defamatory statements. And the defamatory statements were made by both the plaintiff in this case, as well as Gasca. Gasca states that she's a witness, and we've submitted exhibits today, which I'll get to in a minute, but Gasca states on page, I think it's the last page, that she's a witness to Standifer allegedly assaulting the plaintiff. This did not happen. And from any footage in the video, from different angles, it shows that this Dr. Standifer did not touch the plaintiff, nor did he touch Gasca, unless these video surveillance footages have been altered in some manner. He never touched them. He might have yelled and screamed because he was being denied his right to make a purchase of alcohol. He never touched her. And initially in Standifer's Exhibit A, Tom Thumb alleges that Dr. Standifer assaulted Gasca, and that's why Gasca is a necessary party to this action. They then turn around and plaintiff files this lawsuit, I believe the end of last year, stating that Standifer assaulted her. So which is it? Did he assault Elizabeth Gasca, the cashier, or did he assault her supervisor who came over at the beckoning of Elizabeth Gasca, the third party defendant? So which is it? We can't have both. So they've made both arguments and stated that he's hit either one of them. We're saying that never happened. But as far as the statute of limitations, Dr. Standifer is well within the 1 year statute of limitations because his filing was within 6 months of even finding out about the defamation in the police report.
Now, Mr. Sarles argues that the discovery rule doesn't apply in defamation cases. And he cited, what cases did you apply? Did you cite in that?
Ellert versus Lutz, Your Honor, and then the case that we had up on the screen is this Morris versus Unified case. But we've also asserted just simply that the plaintiff's petition specifically says when this happened, when Dr. Standifer learned of this. Paragraph 21 says right here that on or about February 11th, defendant, that's Dr. Standifer, was informed that there existed allegations of him having assaulted a Tom Thumb employee cashier. So
that came from attorney to attorney. Your Honor, I had previously represented Dr. Standifer in the federal lawsuit before it was filed. I was having communications back and forth with Tom Thumb's counsel. That was communications between the two of us, where specifically I was told that Dr. Standifer had hit Elizabeth Gasca. And I was responding to that in our Exhibit A that's been submitted to the court reporter today and filed with the court, because this is what Tom Thumb stated. They can't have it both ways. Did he hit Elizabeth? Did he assault Miss Upshaw? Which one was it? We submit that it was neither one, as the video would clearly show, unless it's been altered. We don't know with today's AI and technology if it has or not, but we submit to you that never occurred, and he only learned of the.
But Okay, so I think they're relying on you. Can you share screen the pleading exactly that you're relying on, Mr. Sarles, so I can?
I am. I thought I was. Is it not on the screen before?
It's not on the screen.
Oh,
I can't see it. Can you guys see it?
No, Your Honor.
can you see it now, Your Honor?
Okay, it says on or about February 11th, 2022, defendant, which is Standifer, was informed that there existed allegations of him having assaulted a Tom Thumb employee cashier, Elizabeth Gasca.
That was the correspondence from attorney to attorney that I was told from Tom Thumb that I relayed to Dr. Standifer. The defamation to a third party, not between attorney and attorney, came from the police report, which Dr. Standifer didn't find out about until 2023. These communications in Standifer's Exhibit A was my office confirming I needed to know, who are you alleging that he hit? Because he stated he didn't hit anybody, and the video shows he didn't hit anybody. So I was confirming exactly what they said, and they said it was Elizabeth Gasca. I didn't even know her name. Where would I have gotten her name from? I had to have gotten it from their counsel, someone with Tom Thumb, associated with Tom Thumb. So I was confirming that. That was attorney to attorney. That's when we learned of it. Dr. Standifer,
as of February 11th, you didn't know about the police report. You just knew about the general allegations.
Yes, sir. So the defamation has to be to a third party, not technically between attorney and attorney. So we have the police report that we didn't learn, Dr. Standifer didn't learn about until the following year, and he timely filed his pleadings within 6 months, even though the plaintiff had filed her initial lawsuit almost a year prior to that. We don't know why they waited. Did they wait because they wanted this to happen, that they were planning to present this to the court today? We don't know. But for some reason they waited. He wasn't served until July. But he didn't learn about the defamation that was communicated to a third party, Dallas Police Department, other co-workers, until that police report. And encompassed within that police report, Gasca says that she's a witness. She's a necessary party, but she doesn't have standing under the anti-SLAPP statute, because there was no retaliation by Dr. Standifer in filing his lawsuit, because his lawsuit preceded the filing of both Tom Thumb's and Gasca's lawsuit. They don't even have standing to bring that.
But what did Miss Gasca do? She didn't file a police report.
She's a witness in the police report stating that she saw Dr. Standifer assault the plaintiff on page.
So you're suing her for being a witness?
No, and she.
You're suing her, I mean, are you suing her because she stated that she saw an assault occur?
And that she was initially assaulted. Yes. I wouldn't have even had her. Where would I have gotten her name from? I've never even been to that store.
Her name, Your Honor, for the court's edification, is on the bottom of the receipt that was given to Dr. Standifer. That thanks, have a good day. You were served today by cashier Elizabeth Gasca. That's where they got her name. But the point's very simple. There is no pleading of the discovery rule in this third-party petition. We've seen the whole thing here. There's no allegation of the discovery rule. As a matter of law, the discovery rule the Dallas Court of Appeals holds does not apply. So the date of the police report, February 1st, 2022, the Dallas Court of Appeals in 2015 says—
Mr. Charles, let Ms. Crenshaw, did you plead the discovery rule in your third-party petition?
I did not, Your Honor, but the Texas Supreme Court and other Texas courts have stated that in determining or looking, when the court's looking at a motion to dismiss, they are to look at the arguments that are made today at today's hearing, as well as the pleadings that are on file with the courts. I
mean, I'd be curious to see those. I mean, I have to look at for the 91A motion, I just look at the pleadings. Correct. And the pleadings don't have the discovery rule. So that kind of takes Gasca out of this, as far as I can see, if there's no discovery rule pled. Does that address it? So I guess for the discovery rule, would that take Tom Thumb and Gasca out of this?
Certainly, Your Honor, as to this false police report allegation, that's all February 1st, 2022. So that's all barred. I mean,
Okay.
I'm not arguing for the plaintiff, Your Honor, but it's barred as to everybody.
In essence, is arguing for the plaintiff.
I'm not dismissing, I'm only dismissing the third party claim, not anything involving the plaintiff. And so if she's made a counterclaim against the plaintiff or something like that, that's not that isn't before me today. So this is only as to the third party claim.
It is set today, Your Honor. Ms. Henderson Love has a motion to dismiss today.
I would like for her to argue that. He's argued for the plaintiff all day.
Your Honor, our motion is set as well today.
Okay. All right. So let's, Mr. Charles, you take it up all the time here. So let me hear from plaintiff's counsel.
Thank you, Your Honor. Very quickly, same argument applies as to page 4 of our motion. Mr. Stanford's basis for his defamation claim is the existence of and the filing of the police report and the plaintiff filing this litigation. He just can't prevail because both of those are basically privileged. She's protected by that. And so his counter petition fails as a matter of law. And there's nothing else that is before him. He doesn't even state that plaintiff has anything to indicate that plaintiff filed the police report, but even if she did, it's time barred and it's privileged.
And we would submit that it's not time barred for the reasons that the aforementioned reasons. But I wasn't finished addressing my argument with the other party, but as far as the absolute privilege is concerned, he did make that argument. So I don't know when the judge wants to hear that. I didn't get a chance to finish.
I guess if the claim is time barred because the discovery rule wasn't pled, then is anything still left? I guess that's what I'm trying to figure out. Is there, if I've already ruled that the discovery rule, since the discovery rule wasn't pled, the defamation claim is time barred, at least as to the police report. Is there anything else left to the motions here today?
The only other allegations, Your Honor, are the allegations of the filing of false pleadings.
There's the anti-SLAPP statute that plaintiff pled, and that's all that she pled in her motion to dismiss. So that was something that I was going to take up.
Well, Your Honor, and
I don't believe about any absolute privilege or anything but the anti-SLAPP stanute, and we don't think that it applies to the case at hand.
Well,
do you want me to make that position?
Well, Your Honor, I would just say to Mr. Stanford's counsel filed an amended response, and I would object to that amended response because it's not timely. It was filed on November 30th, and it wasn't 7 days before the hearing.
But our initial response is on file also, and I have not been able to make an argument against the plaintiff. The only thing that she filed was that she put in her motion to dismiss was based upon the anti-SLAPP statute. And I haven't been able to respond to that apparently because Mr. Sorrells used up most of the time.
Okay. Ms. Crenshaw, what else did you want to say?
That the anti-SLAPP statute is not applicable in this case. And that's the whole argument that plaintiff has used in her motion to dismiss. You have to show that it's a matter of public concern, which it is not. The plaintiff is alleging that Dr. Standifer hit her on the tip of her nose. That is not a matter of public concern. It is a subjective allegation of bodily injury that we submit did not actually occur. Also under the statute, you have to show that the non-movement was retaliating and filed their motion in retaliation to the plaintiff's motion, and that simply is not the case. Standifer was merely protecting his right to petition the court, which plaintiff is stating that was her premise and sole premise for filing her lawsuit. To say that Standifer doesn't also have a right to petition the court goes against the whole purpose of the anti-SLAPP statute. So because Sandifer did not file his lawsuit in retaliation to the plaintiff, and because plaintiff's petition was not filed and related to a matter of public concern, the anti-SLAPP statute would not even apply in this particular case. The courts have also held specifically in the Castleman case at 546 Southwest 3rd, 684 at 688, which is a Texas Supreme Court case, states that we don't even get to the burden shifting process if the plaintiff doesn't even have standing to bring the anti-SLAPP statute, and that we move to the exemptions, which we have argued that Dr. Sandifer falls under at least two of the exemptions in that particular case. And if Your Honor would, we submit that under section 27.010 A2 and A3, that it would be applicable to the case at hand. Section A2 of that statute states that in pertinent part, that if the non-movement is exempt from having the lawsuit dismissed, if the action is brought against a person primarily engaged in the business of selling or leasing goods or services.
Yeah, and I'm objecting to this because she's arguing her amended filing. The goods and services was an amended filing.
We really run out of time on this. I'm granting the motion, the 91A motion to dismiss on the issue of statute of limitations. The remainder of it, you guys can bring up at some, I'm going to allow her to amend the TCPA. You can bring up at that some future time. For now, I'm going to deny it. So, Mr. Sarles, get me an order on this. Anything else today?
Is it just on the false police report pleading, Your Honor?
That's what the discovery will apply to, correct?
Yes, Your Honor.
Yes.
All right.
So just so I'm clear, Your Honor, what is staying in? What part is staying in? Ms. Gaska staying in?
No.
I don't think so. The
Okay,
only thing on Ms. Gaska was related to the police report, right?
Okay, so it's just, so on plaintiff's TCPA claim, you're denying that motion to dismiss?
Correct. So I'm granting it as the 91A motion, and maybe I'm a little unclear. I think that takes is there anything left of the counterclaim at this point?
Well, he has a counterclaim as to the plaintiff. So I'm just curious as to why the court doesn't believe the TCPA is applicable.
Because you have to have a more, I'm sorry.
Go ahead, Ms. Crenshaw.
I was just going to say that it has to be a meritorious lawsuit. We are arguing that it's not a meritorious lawsuit, that it didn't occur, that they first alleged that Gaska was assaulted and not your client. And it has to show, your client has to show demonstrable injury, which she has not shown in any of her pleadings.
That's not what is in the filing, Your Honor.
What's in their filing then? Because
we did not allege any type of bodily injury.
You're not stating that your client wasn't hit on the tip.
She was hit on. She was hit by your client.
She was. You filed an amended petition, and you're alleging that she was hit on the tip of her nose. Initially, you didn't allege that until I brought it up in my pleadings. So she's alleging bodily injury to the tip of her nose.
We're alleging that your client assaulted my client because he did
not.
And Your Honor, just for clarity, under the TCPA, we're alleging that his only counterclaim is as to the filing of the police report, which my client didn't file, and the filing of this litigation. And those both are barred under the TCPA. So what I was asking from the court is clarity as for the basis of the case remaining. That's all I'm asking. What is the basis of his counterclaim remaining? If those two things are not applicable under the statute, if they're protected, how can he proceed?
But we didn't say they were protected.
Objection. I'm just asking for a ruling on my clarification.
Ms. Crenshaw, do you want to respond to that?
Yes, Your Honor. The court never stated that the anti-SLAPP statute was applicable to the plaintiff. You have to show that it's a meritorious lawsuit with demonstrable injury. You also have to show that it's a matter of public concern. Hitting subjectively, allegedly touching the plaintiff on the tip of her nose is not a matter of public concern. It's subjective bodily injury. You have not shown that there was an actual injury. In addition to that, the TCPA states that you have to show that the non-movement's lawsuit was in retaliation to you filing your plaintiff's lawsuit. If you would look at Henri Lipsky at 460 Southwest 3rd, 579, another Texas Supreme Court case from 2015. So because it wasn't a matter of public concern, because it wasn't retaliatory.
I mean, I really don't think that TCPA applies in this situation. I don't necessarily disagree that you may have a privilege. I just don't think the TCPA applies because it's not a matter of public concern. This was an altercation between two people at a grocery store. It's not a matter of public concern. That's my view of it. And so if you want to do continued briefing on this and file a motion to reconsider or whatever, I just don't think it's a matter of public concern.
Okay.
So
if I understand the court's ruling, Judge Hoffman, is that Ms. Gasca and Tom Thumb are out on the alleged filing of a false police report, and that the false police report third-party petition claims against my client are dismissed today.
correct, based on statute of limitations.
Based on statute of limitations. As to the privilege, the allegation was the filing of a false pleading. My clients haven't filed any pleadings before they were sued in the case. So there's no allegation that they filed a false pleading. Even if there was an allegation, it would be absolutely unconditionally privileged.
I agree with you on that. Okay, I didn't get the distinguishing. I didn't think they made that claim against your client, but yes, I agree with you.
My clients, I believe, are dismissed from this litigation.
Your clients are dismissed from this litigation.
Your Honor, just to be
Your Honor.
clear.
But not under the TCPA. But guys, I really have got to go. This has gone
Okay.
way over time.
Okay.
I apologize. You guys have a great rest of your day.
All right, you too.
Go ahead
Thank
and
you, Your Honor.
prepare an order.
Thank you.
Wait. Go ahead and prepare an order on this, Mr. Sarles. Share it with opposing counsel, all opposing counsel. Make sure at the beginning of the order, it says that this was heard on December 4th, 2023. And also make clear the TCPA motion was granted because this was not a matter of public concern. All claims by the plaintiff are barred, or sorry, by the counter plaintiff,
Third-party plaintiff.
barred by statute of limitations and are but not denied the TCPA because I don't think it applies.
Your Honor, we filed the 91A motion as well.
I know, and I granted that.
But I'm representing Ms. Upshaw.
Okay, I'm confused.
When you say you're granting what? I represent the plaintiff, Ms. Upshaw. We filed a motion to dismiss under 91A and
Counterclaim
TCP.
against you, and I've said that your claim that your 91A motion is granted on the issue of this discovery rule.
Okay,
Very well, Your Honor.
thank you.
And the privilege.
And privilege, correct.
So as to the plaintiff,
As to the plaintiff as well, yes.
But Your Honor, real quick, I
Not
know
under
you
the TCPA.